Good morning, everyone, and welcome to PAMIC's first and hopefully last virtual claim summit. My name is Sarah Zuloff. I'm the Vice President and Manager of Compliance and Regulation at the Allegheny Insurance Group, and we are affiliated with Conn Valley Mutual Insurance Company in beautiful Johnstown, New York. Many thanks to the sponsors whose names you see on the screen for their support. Without that, PAMIC wouldn't be able to provide this educational event. So thank you very much, sponsors. A special thank you to our claims committee. We started work on this year's summit, believe it or not, in November of 2019. And then we picked it up again last fall after it was abruptly canceled thanks to COVID. It took quite a bit of effort to put the seminar agenda together. And, you know, please thank the committee members when you run across them in your day-to-day duties, and their names are up on the screen during breaks. Now, with this, I want to put a little plug in for the claim committee. It is not too soon for you to start thinking about becoming a member of the claim committee and help plan next year's claims summit, which will hopefully be in person. It will be in person, I'm predicting. Okay, I'm especially grateful to Ron, Andrea, and Brittany of the PAMIC staff for their assistance and inspiration in bringing our committee's vision to reality. Okay, for all you attorneys, polls will be popping up twice a session for CE purposes. Please answer the questions on the screen. CLE credits will be reported directly to the CLE board. If you need general CE credits or attorney CLE credits, it's our fervent hope that you provided your attorney ID number when you registered. And we're equally hopeful that if you wish to take advantage of the CE credits offered, that you provided your license number when you registered. To paraphrase an ancient saying, no number, no credits. Please email Andrea at PAMIC if you need assistance with the credits. And all these presentations are going to be available on the PAMIC website, and a link to them will be sent after the conference is over. And now it is my pleasure to introduce PAMIC President Ron Gallagher, who has some words for us to kick off the day. Thanks, Ron.
Well, thank you, Sarah. I have two items to share with you. One is a very good news item. So you guys are the second audience to informally share that we will be hosting our convention this August in person at the Hershey Hotel. So look for the registration links, sponsorship links, and if you're interested in exhibiting, those all should be going out within the next couple of days. So that's the real good news. The second item is really just a business item. Because we are a trade association and talking about lots of issues, we do need to be concerned about potential antitrust issues that may arise. If anybody on this seminar feels that we may be approaching potential antitrust issues, please raise the issue directly to me or Sarah using the chat or Q&A function, and we will deal with that issue immediately, so that everybody is aware of the potential issues that are out there. Otherwise, I'm done for now. I'll be speaking a little bit later, but with that, Sarah, it's yours to kick off the actual formal presentations.
Okay, great. Well, we're starting our day today with a very timely topic: social inflation. What's driving the ever increasing costs of claims? We all read these scary headlines, and we have a panel of experts put together here to navigate us through these rocky shoals. How's it for early morning purple prose? So our panel moderator is Lacey Conn, who's a partner with Thomas and Hafer. And she works out of the Virginia office there. Okay, prior to joining TTH, Lacey worked for a large national insurer, during which time she tried several hundred bench trials, more than 50 jury trials, and obtained her CPCU designation. Lacey devotes her practice to representing insurers in first-party property claims, coverage matters, and bad faith litigation, and their insureds in cases involving motor vehicle accidents, premises liability, hotel and transportation liability, and construction defects. Lacey also has experience defending railroads against claims brought by employees and third parties under the Federal Employers Liability Act. Lacey is licensed in Virginia, Maryland, and the District of Columbia, and maintains an active practice in all 3 jurisdictions. And now, Lacey, the floor, or shall I say the cloud, is yours. Take it away. Thank you.
Well, I'm going to jump in, Sarah. One of the things we did when we put this together, so I'm not Lacey, was we talked about whether we were going to do this as panel or as moderator, or how we were going to put it together. And some of the information in this has been gleaned from other sources. So I kind of wanted to give credit to Paul Kalajian. We heard him yesterday during the technology discussion in the morning. Paul had spoken on this issue down at NAMIC, down on Amelia Island last year. So I stole a good amount of this information from him. And also Ridge Muley from Gen Re. Ridge and I had presented some of this material together. So he had added in some things, wanted to give him credit. But the way we're going to kind of organize this is we're going to go through the definition briefly. We have limited time and there are a lot of components to this. So we're going to talk about these drivers for discussion that are listed here in terms of economic disparity. That's basic inequality of wealth, changes in how cases get tried, the reptile theory, jury composition, just demographic changes, which are driving some of the increased verdicts that we see, litigation funding and laws, big business, just changes in terms of the business of insurance and how this differs from maybe 20 or 50 years ago. So we're going to jump right into it. I'm going to handle some of these topics. Lacey will handle some of them. Jeff will handle others. And then hopefully we'll have a little bit of time for questions at the end. But that's always difficult to make sure that we stay on time here as far as the agenda. So if we can go to the next slide here. This word group, word cloud, just deals with some of the things that you read about. Like Sarah said, you know, it's a timely discussion and you hear these headlines about social inflation and nuclear verdicts and just the most ridiculous, well, I don't want to say ridiculous, but, just verdicts that vastly exceed the amount that we would ever really think would be something that would compensate a victim for something that they endured, you know, billions with a B type dollar verdicts. So these are some of the things that all kind of go together to determine, you know, what goes into social inflation. So if we go to the next slide, basically what we're talking about are just the changes in society, changes in the judicial system, changes in some of the economic structures in the country that have changed the way insurance companies have to deal with claims, have changed the ALAE and defense costs that is incurred in dealing with claims, and ultimately the amount of indemnity that's paid out. So if you're looking for kind of a brief synopsis type definition of what social inflation is, it's just changes in the country, judicial, social, and economic, that have changed the amount that we pay. And it's, you know, something that obviously is an evolution over time. I mean, everything's always changing in these structures, but it seems to be that there are certain inflection points in society, just periods in time where these are really, really rapid and they result in really big changes. It's not a new term. I think in various publications, they say it was first used by Warren Buffett in the 70s in one of his shareholder discussions about just the changes in society that are driving how we perceive wealth and the way that wealth is transferred between individuals. You know, you think about periods in time like the 60s, people kind of harken back to changes in the 60s. And if you think about it, it wasn't really so much the 60s, but it was points in time where there were a lot of really quick, rapid changes. 1964, we had the Civil Rights Act. 1964, the Beatles were on Ed Sullivan. Things like that really started changing the direction in which the country was moving. And we've seen a lot of acceleration in the last couple of years. And this was pre-pandemic, right? When I put this presentation together with the help of some other individuals, it was before COVID. And we were talking about the changes in society. So a lot of this is really only exacerbated by the changes over the last year. So we're going to talk about changes in the legal system, changes in jury composition, and law and big business. We can go on to the next slide. So everybody, or most, might remember this, right? The first topic's economic disparity. And so this is a poster from Zuccotti Park during the Occupy Wall Street movement. And that was now 10 years ago, right? That was September of 2011. And I put this up here, not necessarily that this was the start of anything, but it's kind of a point in time where I think that the national dialogue started changing to a narrative regarding social and economic disparity, economic inequality. If you'll recall, what was kind of the, the sign at that protest was, "We are the 99%." And was talking about the 1%. And that has to do with simply who controls wealth in this country. It's a question of the fact that, 50% of this country, the population, 50% of the population owns less than 2% of our entire economic wealth, while the top 2% own 35%. So the rich are very, very rich and getting more so, and the poor are pretty much stagnant. So that disparity between the haves and the have-nots drives a lot of the factors that we're going to talk about today. We can go on to the next slide. So first off, it's the worst that it's ever been. The gap between the have and the have-nots has widened, is increasingly more so strained at the extremes. The inequality gap is greater than it's ever been. And that's even more so now that because of the pandemic. I mean, before the pandemic, it was something where this was an issue. Now it's something where it's approaching a crisis, because the people who did not have the wealth in the country are the ones who lost their jobs. I mean, those are people who were waitresses and waiters and worked in stores that closed. They could not work from home, and they lost their jobs and had difficult time putting money or food on the table and paying their rent. On the other end of the spectrum, people who had jobs and had some degree of wealth were able to work from home. They were able to quarantine, keep their jobs, keep an income. And so the impact on them was not as extreme as it may have been at the other end of the spectrum. So it was bad, and the pandemic only increased that disparity between the haves and the have-nots. We can go to the next slide. So these are some of the statistics that bear this out. If you forget about the pandemic, unemployment and poverty are generally pretty low in the country, but the inequality is fairly high. And that goes kind of to the last point here, and that's that the top 1%, their assets have doubled in the last decade, while those in the bottom 50% have remained flat. So again, that's just kind of the idea that the division between individuals with wealth, and that's going to kind of be a litmus test for, or a moniker that we impose on corporations when we talk about insurance claims. But those that have money and those that do not have money, that gap has widened. I want to go on to the next slide. So what this talks about, or what the impact of this is, and I'm not saying it's something that's extreme, like the revolution is coming, or we're the storming of the Bastille, but it is an idea that I think one has to be cognizant of in kind of a historical perspective, because I mean, At the end of the day, this is just Marxist dialectical materialism in action, right? Like, so the Romanovs ruled Russia for 200 years or whatever the case may be, and it did not end so well for them. History teaches us that forever, when wealth becomes increasingly concentrated in the hands of the few, eventually the many go take that. You know, that's not the point of this presentation, but how does it impact social inflation and how does it impact jury awards? Well, it largely has to do with the ability of those individuals, of people who don't have money, who sit on juries and who have a greater say because there's simply more of them and increasingly more so. You know, how they view verdicts and how they view the redistribution of wealth and taking money from corporations and insurance companies and redistributing that to individuals who might not have a lot of resources. And then who's sitting on the juries that are making those type of decisions? Millennials, individuals who came of age during the 2008 housing crisis, people who were at the Occupy Wall Street movement. I mean, they were there in the tents. You know, they're now the largest segment of the population. Jeff's going to talk about that in a little bit. But, you know, just in terms of kind of the entire issue here, it's the people without money, that population, segment of the population is increasing. And people who distrust corporations, that segment of the population is increasing. And that's a recipe for some jury verdicts that are astronomical, that impact corporations and thereby impact insurance companies, and just increase the entire price that we're going to pay for claims and in litigating CGL type claims. So if we want to go on to the next slide, that all rolls also into the perception of wealth. And in the not too distant past, this is what we thought a millionaire was, right? Like, so when I grew up in the 70s, you know, that was certainly a level, right? Like, oh my gosh, that person's a millionaire. That meant something. I mean, it was kind of a ceiling or potentially a floor, but it was a level that existed. And if you were a millionaire, you were rich. It meant something. And that's not the case today. If we go to the next slide, here's what we see today. And this plays into a lot of things like social media and the way that people in our society are perceiving wealth. But it's something where $1 million just isn't a lot of money. I mean, Kylie Jenner, who to my understanding is a Kardashian of some sort, sold half of her cosmetic company for $600 million. And she was 22. Might be wrong on that, but somewhere around there, early 20s. And so what does she do? Well, she tweets that she just sold half of her company for $600 million. And, you know, 50 million people who follow her on Twitter or Instagram or whatever see that as an amount of money, a reasonable amount of money, a lot of money, but it's not $1 million. $1 million becomes pretty quaint real quick. I've included some others here. Bryce Harper. I mean, every year in sports, right? It's who has signed the latest contract for the most astronomical amount of money to play baseball or basketball or whatever the case may be. But again, people who follow sports, people who are younger, you know, my kids say, oh yeah, Bryce Harper is getting paid $330 million. Well, again, that's not $1 million. That's $330 million. $1 million. I mean, Bryce Harper doesn't even wake up and get out of bed for $1 million. That's so little money. It's not even, and that's what my 13-year-old says, right? He says $1 million. Well, it's not like that's $10 million or $50 million. And when I was his age, I mean, that would be crazy talk. I mean, $1 million was an astronomical amount of money. Will Smith down there got paid $100 million to be in Men in Black 3. And I don't know, that came out what, like 15, maybe 20 years ago? $100 million to be in a movie. I mean, I don't know how long it takes to film a movie, but it's like 6 or 8 months. $100 million. And then Jeff over here. So you can tell I put this together last year, right? In 2020, when his net worth was 151 billion with a B billion dollars. I didn't check what Amazon stock price is today, but recently Jeff was worth close to $200 billion. I think it was 191. So he made $40 billion in less than a year. And if you think about it, I mean, Jeff can put that money in a 2% savings account over at the credit union with the penny saver, and he's bringing down about $500,000 an hour. So in the time of this presentation, Jeff does nothing. He goes and makes some popcorn, sits down and watches Peaky Blinders on Netflix and comes out $500,000 richer. That's a lot of money for doing nothing. But again, that's what you see in the news. That's, I don't want to say that's what the kids see, but I mean, that's people who follow social media, and younger generations see this amount of money as a number. And then when they're on juries, this becomes a real number. So if we go to the next slide, basically $1 million is just a lot less than it was 10 or 20 or 30 million or 30 years ago. Today, when you're talking about a jury verdict, it's a lot different. A while ago, it was, we're going to give this person $1 million. And that was kind of a threshold. It was, kind of like the Dr. Evil Austin Powers type thing. And that's not the case anymore. Now people talk about 5 million, 10 million, 20 million, billion-dollar punitive damage awards. And it's just because of the perception of wealth. It's how society has changed. The social media, I mean, when celebrities tweet out things like, here's my $50,000 handbag or $100,000 sweater that I bought. I mean, people start understanding that, those are amounts of money that for whatever reason, they're not tied to reality. So my summary to this part is, if Will Smith gets paid $100 million for one movie for 6 months of work or so, if you think about it, it's true. How much is a life-altering accident worth? I mean, how do we value a fatality? I mean, if somebody's killed in a car accident, isn't it pretty difficult to say that life is worth $1 million? If Will Smith is getting paid $100 million for a movie, or Jeff Bezos is making $500,000 watching Peaky Blinders. It's just a difficult narrative to sell. And I think, it makes sense to me, even as a claims guy, that, if somebody like that is getting sued, I really don't know that I have as much problem taking $500,000 from Jeff Bezos and giving it to somebody else as I might, just a Joe Bag of Donuts type defendant. So that's kind of setting the frame of just the amount of money that we're talking about. I'm going to turn it over to Lacey, I believe, who's going to talk briefly about Me Too before handing it to Jeff.
Thanks, Adam. Yeah, I'm going to start with the trend that we've been seeing really just in the last 4 to 5 years or so in the increased amount of claims involving sexual misconduct. And so specifically, what we're talking about is this #MeToo movement, which actually started back in 2006 from a sexual assault survivor who wanted to coin the phrase and use the phrase so that other women and other survivors felt comfortable coming out and reporting their own stories. But that it really didn't happen. It really didn't happen until 2017, when Ashley Judd gave her account of her encounters with Harvey Weinstein to the New York Times. And it skyrocketed from there. If you look at the timeline, it's crazy. So it's her New York Times article was like October 5th. And within the next month and a half, all of these huge figures had fallen under the #MeToo movement, which was actually Alyssa Milano retweeting the New York Times article and saying, reply with Me Too if you have survived sexual assault or sexual harassment. And what that's resulted in is it's not an increase in sexual assault, it's an increase in the reporting of sexual assault, sexual abuse, and sexual harassment, which has led to more claims. And then on the other end of that, so not only are we seeing more claims involving allegations of sexual misconduct, but we're also seeing at the other end larger settlements and larger verdicts than we ever have before. So I've got 3 examples on this screen for you. In 2017, there was a $90 million settlement between 21st Century Fox and their shareholders over losses related to two sexual harassment accusations. In 2018, there was a class action settled by USC, and that was just increased, just announced this past March of 2021. There was an additional $852 million added to that 215. And this is what USC will pay for the women. There's 710 women that have reported claims against one campus gynecologist. And these assaults go back 20 years. And this is how the Me Too movement has increased claims, right? This is the direct example. The assaults were going on for more than 20 years, but people weren't reporting them. Come Me Too comes along, now they're getting reported. Now we have this $1.1 billion settlement. And the same thing happened I have Michigan State, but this is of course Larry Nassar, he was a Michigan State doctor, but also the USA Gymnastics doctor and the US Olympic team doctor. And again, these reports of these assaults go back more than 20 years, but it wasn't until October of 2017, after Ashley Judd, Harvey Weinstein, Alyssa Milano, all these come forward, that the first report against Larry Nassar was brought out. And then we have 2 years later, we have the settlement of over $500 million. It's $425 million to the current victims, $75 million to be held in trust for people they think have not yet come forward. And this was for a total of 332 women over more than 20 years, but it took this movement to have them report. So that's just a very brief bit about Me Too and sexual harassment. And I'm actually now going to turn it over to Jeff, who will talk to you all about the ever popular reptile theory.
Thank you, Lacey. Just before I get into that, I just have to comment. Adam mentioned Bryce Harper. As a Mets fan, I can tell you 13 years is too much. You all can comment in the chat. Go ahead. But 13 years, way too much. Anyway, reptile theory. Many of you probably have heard about this. Plaintiffs have been using it as a tactic for about the last 10 years. Unfortunately, it's not just 1 or 2 plaintiffs. It's plaintiffs all around the country. Plaintiffs' attorneys are very organized. They chat in meetings like this, they read the same blogs, they get the message out, unfortunately better than the defense side. They're unified and they all know about this. So what does it do, the reptile theory? Like it says on the slide, it feeds the juror's desire to expose and punish the existence of danger when it exists in their community. It focuses on the defendant's failures and shifts the jury's thinking from the actual injuries involved. It doesn't matter, the facts of the case don't matter. What matters is the policyholder needs to be punished and society needs to be saved. It elicits a gut reaction that leads to the tendency to give damages, again, based on a broader perception of safety. Plaintiffs' attorneys in the past would always focus on this one plaintiff. Is the plaintiff sympathetic? Us on the insurance side, we would ask our defense counsel, is the plaintiff somebody who's sympathetic? That matters less now. Reptile theory is more successful because the emphasis is on the individual juror and his or her safety in the community. And this all comes from a book, which you can order on Amazon to plug Jeff Bezos in 2009. Lacey, can you move to the next slide? So here we have the traditional liability script and the reptile theory script. I'll give you an example that I was just involved in a few weeks ago. I'll talk broad, to not punish anyone, I won't give actual names, I'll talk generally. Case out in California, the policyholder was involved in a car accident. It's a business where the claimant was in the vehicle. Claimant was in the last year of his life. No question about that. So the claim was worth somewhere between $100,000 and $125,000 worst day. That's what our defense counsel's analysis was. That's what the analysis was of jury verdicts, etc. So plaintiff was completely unreasonable and wanted the remainder of the $1 million policy limit. Carrier said no, went to trial. It seemed like the right idea. If you're going to pick a few cases a year to litigate and take to trial to make a statement that you're not just going to pay on everything, this was the case. The person, again, had 1 year to live. He was unfortunately a very sick individual. Went to trial. His daughter brought the case. She was an adult. Plaintiff utilized the reptile theory. He did not make the case about the liability of the policyholder. He made the case that this type of accident and this type of business threatens all of society. You, the jurors, will be in deep trouble. You won't be able to go on the highways and the local roads or walk on the sidewalk if these types of policyholders are out there conducting their business. Went to verdict on a case where it was about $125,000, worst day. The jury came back just a couple of weeks ago with a $4 million verdict. Now, this is very interesting. After the case ended, we were actually able to interview a couple of the jurors, which is rare in civil trials. So not polling them after, but an actual sit-down interview. They hired an investigator. Two jurors both commented, oh, we don't know anything about the liability. I don't know if he was liable. They used the word guilty a couple of times. We don't know if he was guilty. All we know is we wanted them out of business. That policyholder should never remain in business. They cannot stay in business. And that was the whole verdict, what the whole verdict was based on. Now, it's a $4 million verdict that will be appealed, but how much will it actually come down? Who knows? The reality is now the carrier is going to be in a position where they probably have to settle for well north of the policy limit if their settlement can be reached prior to the appeal being heard. Next slide, please. We have up our first morning poll question. I guess the question is, how did you find this seminar? So everyone's supposed to, I guess, respond and send it in. So in essence, the plaintiff's bar method of trying cases has changed, as I mentioned, over the last 10 years. This is all not focused on just compensating the plaintiff. It's using the money awarded to the plaintiff to change the defendant's behavior, like in the example that I gave you. Now, a lot of people ask, well, what can be done on the defense side to deal with the reptile theory, to counter it? One thing you would hope defense counsel tries to recognize this is happening and make motions to the court and say, hey, look, this is a distraction. This is just tricking the jury. This is not appropriate, and make motions to get that plaintiff to stop utilizing the reptile theory, not usually successful. And then the other thing that is being recommended now is defense counsel look to try to humanize the policyholder as well. It always was about humanizing the plaintiff, but if you can try to humanize your policyholder, you can possibly counter the reptile theory. Okay. Next slide, please. Now, Adam mentioned this before, millennial jurors. It's critical to recognize who's sitting on these juries now. It's not baby boomers. It's the largest part of the population, these individuals born between 1981 and 1997. There are 75 million of them, more than the baby boomers. And again, they are sitting on your jury. They are 25% of the US population and 40% of the working age population. They're more highly educated and diverse than prior generations, and more than a third, ages 25 to 34, are college graduates. Again, this is on who was on your jury. Adam mentioned this briefly before. They've been hurt by the recession. Many chose higher education as an alternative to labor force participation. They took on debt when fewer family resources have been available, entered the job market that was only tepidly returning to normal, and they've been disproportionately hurt by recent COVID job losses. You do read about more and more millennials going back home to live with mom and dad. Again, this is who is on your jury. Next slide, please. So again, these millennial jurors, the people who are sitting there deciding these claims, if should you decide to go to trial, they grew up with the internet and social media. They are able to absorb vast amounts of snippets of information in a short time frame. Think about just reading the news on Twitter or TikTok or Instagram or whatever you're doing. Worldview shaped by 9/11, helicopter parents who are down observing everything they did on top of everything. And again, they've experienced deep periods of economic loss. Unfortunately, they're also, according to some studies, most distrustful of corporations and institutions, much more so than prior generations. And getting back to my first topic, they're unfortunately, because of this, more susceptible to the reptile case. And again, these are the people sitting on your jury. So when you're reviewing a claim and you're deciding, should this be the claim to go to trial, part of the exposure analysis should be, okay, we're probably going to have a jury with a large amount of millennial jurors. Is this the type of claim that is susceptible, where the plaintiff will be able to utilize the reptile theory? Or in general, is this the type of claim we want to go before a jury when we know it's millennials? Next slide, please. I'm going to turn it over. Lacey, were you doing litigation funding or Adam? I don't recall.
I think I'm doing that one. Okay, so litigation funding. So this is basically when a third party not involved in the litigation is going to make a loan to the plaintiff based upon the outcome of that litigation. It's new to the United States, relatively new. I mean, it's probably been increasing over the last 5 years, but it has been used in other countries, Great Britain, Australia. It's really not subject to some of the interest rate or usury laws that we have regarding those loans because it's non-recourse and a somewhat contingent basis. Next slide, please. So how does this impact social inflation? How does it impact the nuclear verdicts that we talk about? Well, two ways. I mean, a number of ways, but first is really that there's a lot of expertise there. So let's pick a small law firm, small plaintiff attorney in Iowa somewhere, just to pick on Iowa because we can. And somebody goes down, it gets an attorney and has a case, and that attorney normally would bring the case and have experts there in town, and the amount that they'd ultimately settle for would be X. Well, let's say that litigation funding from Chicago gets involved in that case, and they loan the plaintiff some amount of money. Well, then they have an interest in maximizing the amount of that recovery. So they have experts, they have chiropractors, they have doctors, they have accident reconstructionists, which might not be something that the small town attorney in Iowa would have access to or would normally use, but there's a whole stable of individuals who might look at this plaintiff and say, that plaintiff has a traumatic brain injury, which may never have occurred in your regular run-of-the-mill small case in Iowa, but all of a sudden the damages and the specials go up. And that degree of expertise is something that adds a lot of value to that case. And in addition to that, it's simply the leverage aspect of it. I mean, if the plaintiff has already gotten paid, and they may not need the money. And that's not to say that the settlements, that we leverage settlements based on that, but cases are what cases are worth, right? And if somebody needs money to pay for their bills, in the event that they get that from another party and kind of give up on their case or don't care about their case or don't have as much of an interest in the case, they've already been paid. So they don't have as much of an incentive to settle the case or reach a reasonable resolution. So attorneys and the litigation funding people can hold out, increase the cost of it, increase the ALAE, increase the defense costs, all things that we're talking about in terms of social inflation. It's not simply the amount of money that is paid in indemnity, but it's the entirety of the process. So litigation funding can drag things out, make settlements more difficult, and increase the value of cases by experts and by other individuals that you might not normally see in a case. Lacey, we can go on to the next one, please. In conjunction with that, we've got medical funding. So I can summarize this in terms of normally somebody is injured, they go to the doctor, they go to the hospital, they have health insurance. There is an amount that is paid for their treatment, and that gets boarded, and it's $20,000. Well, in these instances, somebody goes to the hospital and in essence, they do not use their health insurance. They have a third-party funder pay for it. Well, if that person pays for it, then those specials are 2 or 3 times as much. So when you get to a trial, rather than boarding $20,000, you can board $60,000 or $75,000. And we all know that not only does that increase the amount of recovery for the specials, that's going to impact pain and suffering. Just in the general course of things, the claim is worth more. So medical funding as a mechanism increases the costs of claims by increasing the amount of specials that somebody can board. And both of these things run into the next slide, or the next slide. I already said that stuff. Okay, so law is big business. 50 years ago, and probably less than that, but for the last 100 years, let's say, like if you think of attorneys and courts and judges and things like that, this is kind of what you think of. This is kind of the picture that plays in people's minds is Perry Mason, not the Perry Mason on HBO that was excellent. Hope you watched that, Steve Krug. This is kind of what the picture was. And this is not what we have now. If you go to the next slide, Lacey, now we get this. So we've got the gorilla, the butthurt thing. My 13-year-old just thought that was really funny. Crash Cash. We've got Lowell the Hammer Stanley down in the lower right-hand corner. If you ever want to get on YouTube and check out fun, lawyer advertisements like I do in my spare time, check out Lowell the Hammer Stanley. Also, I think it's Texas Law Hawk. Great advertisements for plaintiff attorneys. Up in the upper right-hand corner, we've got Nasty Boy. That guy is an attorney, so that's not an actor. That guy, or a professional wrestler who gave his image to this, that's actually an attorney, Nasty Boy there. So it's advertising, and this isn't something that we had 50 years ago. And I'm not going to get into the whole change, in the Supreme Court and freedom of speech and all that kind of stuff as to why this changed. But it is a change, and the change has increased the cost of claims because it really plays into this whole narrative of law has become something other than simply compensating people. Lacey, if we go to the next slide, there's some statistics here just in terms of the correlation of the broadcast advertising in some markets, the increase. So more ads on TV. I mean, if you're sitting at home during the day watching Hogan's Heroes, like most of us have been over the last year, that's what you see during the day, right? In any ad break, the majority of them are ads for, hurt in a car, call HHR, or, well, Scott might be watching, so, a better advertisement than HHR. But, what that does is it increases the amount of attorney representation that you see over here on the right-hand side. And the reality is that the more attorneys that are in a case, or the greater the representation, simply the amount of ALE, litigating it, everything is going to cost more money. Go to the next slide. So advertising not only increases the litigation, but it also fosters an anti-insurance company bias. Any of those advertisements that you see during the day, they are all basically the same script. And I don't want to be too pejorative about it, but it is, I was hurt in an accident. I called the insurance company and they tried to rip me off and gave me a lowball offer. And then, it's cut to an attorney who goes, bum, bum, I'm here. And it's, I settle claims, I hammer insurance companies, I'll get you the maximum amount of money that you can possibly get. And then, it cut back to another person who goes, I called whomever, and whomever got me paid cash, and, thanks, attorney. So it fosters a narrative that exists in our society that insurance companies are evil, and insurance companies are trying to rip people off, and insurance companies make their money by not paying claims. And we could have a deep analysis and discussion of how actuaries would say that if that was really true, insurance companies will all go out of business, but that'll be saved for some other time. Litigation funding, so these litigation funding outfits are like the real deal, right? I mean, like 20 years ago, you were talking about Phil Rizzuto, Money Store, J.G. Wentworth type stuff. And that's not what these cats are about. I mean, there will be people who graduate this year from Wharton and from MIT and gold-plated Harvard MBAs who will not go to Morgan Stanley, but will go to a litigation funding outfit in Chicago. It takes the largest one in the United States, I think, takes up 3 stories or 3 floors in a skyscraper out there. I mean, they use predictive analytics and economics and return on investment to get 30, 40, 50% returns. And they make a ton of cash doing it. But what that means is, you know, it's a commodity and it's not about justice anymore. It's not about fairness anymore. It's about big business. And a lot of people, a lot of our great sponsors, you know, they are the doctors and chiropractors and accident reconstructionists and SIU folks. You know, they've got a stake in this. I mean, the bigger and bigger it gets, the more law becomes a commodity, the more it becomes a business. There are more people who provide tangential services and necessary services. So, you know, it has to be this way because the pot of money is just so big that more people are involved in it. And finally, the plaintiff's bar, I mean, you know, and all credit to them. They are extremely well organized, funded, and politically connected. They give more money to elect the entire Pennsylvania Supreme. I meant they give money to, you know, to judges and to put people on the bench, and they're connected. And you know, they have a really strong lobbying arm. And you know, that's one of the things that PAMIC does, right? I mean, PAMIC is a informational way of you know, getting people together to realize that. And that there's another side to the story, especially in insurance claims. So that's kind of my my law is big business. I think that's the last one I have here. And now we're going to go back to Lacey, I believe.
Thanks, Adam. We did have a question, and the question is, do we know what plaintiff counsel charges for services? I assume it's a percentage of award plus legal fees. I know typically, and Adam and Jeff, please come in, the typical is a 33% contingent fee, and then that increases when it goes to trial, you typically, at least in Northern Virginia, to 40%. So the part of why this idea that now even small cases need representation or getting representation is you're automatically adding 33 to 40% to the ultimate amount that the case has to settle for in order for the claimant to make the same amount of money, right? So that again is driving up these costs. Is that typically what you guys are seeing, that 33 to 40%? Yeah, so.
Yeah, that's fairly standard.
And that's in, you know, I think all personal injury cases. What I found interesting is on Adam's slide, and maybe you can speak to this, Adam, is that there's representation even in PIP cases. So in certain sort of first party recovery cases like that in Virginia, the attorney can't take a cut. I don't know, Adam, is that different in Pennsylvania?
Yeah, I mean, I think that, you know, it's not just PIP. I mean, it's a lot of, you know, you see this same thing play throughout the industry. I mean, this is what, you know, professional adjusters getting involved in property claims, right? Like it's so whatever skin you put on it, it is more people coming into this line of business, whatever the line is, whether it's PIP or property or whatever the case may be. And taking a percentage of the cut, which increases the entire cost of the claim. So, I mean, that's really kind of the problem that is pervasive and adds to this entire topic.
We won't talk about public adjusters here because we will not have enough time to do anything else. Let me just say my favorite commercial with the evil insurance companies, and I don't know if it was a national commercial or not, it was a few years ago, and these big guys, older, white guys with suspenders on, and they're all smoking their big fat cigars, and they're, oh, we're the insurance company. Oh, they're represented by so-and-so, and they're like, they spit out their cigars, and they're, oh God, settle. And it's just, I can't remember. It may have been the Cochran firm, I can't remember, but it shows you, exactly what people think about insurance companies. We just got our second poll question, if y'all want to answer that, so that you can get your CECLE credits. So the next topic is defense bar disconnect and slippage in industry expertise. And we're talking about sort of two distinct ideas here. The first is that the defense bar either doesn't know how to deal with, what Adam and Jeff and I talked about earlier with the millennial jurors, the reptile, the #MeToo movement, or they don't know how, or they aren't recognizing it. And then in conjunction with, we're losing experience from both the defense bar and the claims perspective, as we are losing boomers, as people are getting ready to retire, and we don't necessarily have people with experience that are waiting in the wings, ready to replace these people. So part of the problem, and I've been doing insurance defense work for about 15 years now, and even when I started, people were talking about the good old days and how things, used to be done. But, even now, I think there is a hesitancy on the part of some defense counsel to really use technology. I worked with a guy who used to say, well, I can't bring a computer into the courtroom. The jurors will think I'm some rich lawyer. And it's like, no, everyone has a laptop now. And that's part of what you need to do, right, to connect with these millennial jurors. You have to use technology. It's the flip side of the CSI effect, right? In defense, in criminal cases, they all want to see DNA, right? Well, in our cases, you do have to use technology. And trust me when I say that plaintiff's lawyers are. And every case is, being blown up. Again, what Adam was just talking about, there aren't really any small cases anymore. Every case is a TBI, right? The missed cases are things of the past. Everything it got some sort of component of a big production, accident reconstructionist, TBI. We have a lot of the life care planners. That's all come. And so we need to be ready to deal with that, but also to recognize that it even exists. Jeff talked earlier about combating the reptile theory. You have to be ready from a claims and defense perspective to deal with that when the case is filed, and deal with that all the way through. We've had very good luck in Virginia, and there are several standing orders in place now that does not allow the reptile theory, because it invades the province of the jury and violates the golden rule by asking jurors to put themselves in the shoes of the plaintiff. But that was a battle. I mean, I have been fighting for at least 5, if not longer, years of motions in limine, objections, and instructing my clients not to answer during deposition, getting in front of the right judge, getting in front of the right judge again. And so I think that, we have to be recognizing these things from both claims and defense counsel, and, recognizing them from the very beginning, but then passing it on. That's the other side of this. Once you recognize it, you got to train the younger lawyers to do it. Part of the problem you guys all know with the increasing rise of claims is we don't try as many cases. So, it's all well and good that I have all my, trial experience, but if my associates don't get any, how do they learn how to try a case? How do they learn how to value a case? I was having a discussion with the mediator that I appeared in front of many times when she was on the bench. And I was asking her about that. How on earth does a newer person, and by newer, I mean someone with 8 or 10 years of experience who's only tried 2 jury cases, properly value a case and say with any credibility to plaintiff's counsel, I know what a jury's going to do? And so it's, it's hard, right? It's claims are getting more expensive. So the tendency is to settle them, but then we're losing, that experience on both the claim side and the lawyer side. think I have another question. One of the questions is, are you legally liable if someone is sexually assaulted in your house? So I can speak off the top of my head to Virginia, Maryland, and DC and say it depends, like any good lawyer would say. There are theories that would allow recovery, but there are theories that would not allow recovery. So it depends on who the person is that was assaulted, who the person is that did the assaulting. But certainly I would expect, you know, Adam and Jeff, that sort of claim to be turned over to an insurance carrier. And I don't know what you guys would do from there.
No, I mean, I think we would do exactly what you've been talking about. We would treat it like any other claim. We would go in, there would be an investigation done by the carrier. An attorney would investigate, et cetera. And I think it would be handled like anything else. But again, it would depend I think it would be jurisdiction by jurisdiction as to what the possible potential liability is.
Yeah, I think that it's very fact intensive. I mean, that's the problem with the hypothetical is, you know, it really does depend on what the real facts are.
You guys got 3 lawyers as panelists today. So, you know, it depends. The second question we got is, yesterday, the concept of functional degradation as it relates to roofs was raised. Most policies cover damaged roofs and is silent on functional degradation. It seems to me that this is another form of social inflation. If so, are you aware if there is an increasing mitigation over that issue? I don't know. Either of you have experience with that?
Yeah, I don't. I mean, I call the property guys when those questions come up. So
same. I do the same.
I can't even give you an it depends on that one, guys. Sorry. We'll have to pass that on to the property people. So let out of that. Okay. And the other thing about the defense bar disconnect is, again, this idea of preparing that Jeff was talking about earlier. We got to prepare. And I think, you know, everyone is at times guilty of saying this is a smaller case. We don't need to do this. The jury will never believe that. We don't need to have an expert. Every case needs to be treated if it's going to go full bore. Be ready to attack the life care planners. Be prepared to provide to the jury an alternate. And what I always do now in all of my closing arguments is I give them a number. I didn't for a number of years. I am now a true believer that even though I come in and thinking this is 0, 0, 0, 0, I don't need to give them another number. That's not what we're seeing. That's not the trends that are happening, even in very conservative Northern Virginia. You got to give them a number. You got to pull them back down to reality. You got to say, here's the number that makes sense. This is what we just talked about with people retiring, and again, the erosion in the case evaluation skills, and frankly, the ability to try a case. And then the failure to invest in the tough case. It's going to cost money. And the reason it's going to cost money is everything we've talked about, especially the litigation funding and the medical funding. I think the last topic we have, which I don't really like talking about anyways, so I'm just going to breeze through it so that I think Adam, I can't remember, but I can conclude us here before time's running. Any bodily injury case that exceeds $5 million, we don't like to think about that. It does happen. You guys can read through this. This presentation will be available to you, but here's some of the reasons, all of what we just talked about. And then, of course, the Johnson & Johnson and Roundup cases that we're all very familiar with. Don't like to talk about those. So Adam, you want to, or Jeff, I can't remember, sorry, you want to bring us home on this?
Sure. So, I mean, you know, I don't do a lot of conclusion. I mean, everybody hopefully paid attention and got something out of this entire rigmarole. But you know, generally, I think it's just the fact that, you know, what we perceive to be a lot of money has changed. And that means that when people are awarded a lot of money in a jury verdict, it's more than it used to be. And there are things that have changed in terms of trying cases, such as the reptile theory, that are honed in on that and try to, increase the value of any kind of verdict. Things like law is a big business in terms of the amount of money that's in play and the number of people who are involved in it, have changed this, kind of like a reptile theory, from compensating victims and justice and fairness into something about money and deterrence and changing behavior and getting paid. And all of those things simply put more dollar signs at the end of a verdict. And that's why this is a topic that has kind of evolved and will continue to evolve as some of these things are exacerbated. As more millennials are on juries and less baby boomers are on it, as economic disparity changes, as more 20-year-olds sell their companies for billions of dollars, all of those things kind of play together to change the price of poker and increase the value and amount of money that we're paying on claims. So that's about it. We did a pretty good job getting that in by 11 and keeping everybody on track. So that's all we got. And I guess we will throw this back to Sarah.
Well, thank you very much, panel. You did a wonderful job of framing the problem and then giving us some potential solutions. Really informative. Thank you so much for all of your excellent research and really concise presentation. There was an awful lot of material there. Okay, we're going to take a 15-minute break, and we're going to get back at 11:15 with a presentation by Stradley Ronan on COVID and business interruption. We're definitely looking forward to that. You don't need to log out, just keep the Zoom thing going, and we'll see you back at 11:15. Thank you.
Electrical failure is a big source of fire, personal injury, equipment damage, and lost business. In fact, fires in commercial buildings cause billions of dollars in damages and injure more than 1,000 people each year. What if I gave you the power to look inside your book and detect electrical failure hazards before they cause serious loss of property, income, even lives? Would you be interested? Of course you would. But how, you ask? While electrical failures cannot be totally eliminated, they can be significantly reduced by applying an electrical risk management strategy, one that leverages engineering knowledge, data, and analytics to help your customers keep electrical equipment and systems operating efficiently and safely. HSB's Electrical Risk Management Program brings technology-driven solutions to pinpoint hotspots so equipment owners can get equipment repaired before it fails. Advanced data and analytics allow us to evaluate conditions and make recommendations to mitigate potential losses. And because we understand each risk has a unique set of conditions and each electrical system has unique characteristics, we apply a consultative, client-centric approach to understanding your customer's operations. Working together, we can design an electrical risk management solution to meet your underwriting and risk assessment needs while helping your customers improve their electrical failure prevention efforts. For more information about electrical risk management, contact your HSB representative.
Hi, Ivo Raguzzi, owner and president of Optima Security Services, known as Optima SIU. We've been in business for well over 20 years, and we have serviced the insurance community during that entire time. This is our only line of business. Your 100% solution to all your SIU issues. We take care of it all, which separates us from the pack. We can take care of your fraud plans, your annual reports, your mandatory reports, and most importantly, your training, along with all the investigative needs that you may have. Our reach is throughout the entire United States and Europe. We have handled investigations all over the place, including Alaska and Hawaii. You can come to us. We have experts located throughout the country, capable and able to handle any investigation requirement you may have. I have a fabulous team of experts who have been at this for many, many years, and we're ready, willing, and able to help you in a very professional manner to handle all of your SIU needs. Our experience has shown that we are far more cost effective than an in-house operation. We are truly cheaper, generally about 50 to 60% of the cost that you would have to pay for an in-house team. You know us, you know what we can do. We've presented at your seminars, we have given you information, free tips, and we're always available to you just for questions. Call us at any time, and we're here. We are truly insurance fraud experts.
Well, good morning, everyone. It's 11:15 and time for our next session. We're going to hear from three distinguished panelists, moderated by our president, Ron. And we're going to be talking about COVID issues for insurers, business interruption, employer issues, and a Department of Insurance update. So I'm really excited about this presentation. And let's start out by introducing Steve Davis, who's a partner at Stradley Ronan. He's a nationally recognized insurance regulatory and coverage practitioner. As chair of Stradley Ronan's insurance practice, Steve helps manage the firm's insurance-related transactional, regulatory, and coverage litigation engagements. For more than 25 years, he's provided skilled and experienced counsel and services in hundreds of insurance and reinsurance, regulatory coverage, and litigation matters. Steve has also served as counsel of the Pennsylvania Insurance Department and now serves as counsel to the PAMIC Board of Directors. Steve, it's all yours.
Sarah, thank you so much. Good morning, everyone. We really appreciate this opportunity. As always, Ron and Andre and Brittany have done a great job of getting us situated this morning. I'm just gonna briefly introduce my team here. Adam Brown is an employment lawyer here at Stradley. He helps a lot of my clients with issues that come up in the employment space. He's also a litigator and handles those unfortunate matters. And he's going to talk a little bit today about really how things are shaping up in light of COVID and some of the issues that employers are facing, and I'm sure all of you are facing. And then, of course, how that comes up in the claim context a little bit. We can think through that as we talk about these issues. And my partner, Jeff Grossman, who I think most of you have met before, he is co-chair of the insurance practice here with me and does pretty much everything Sarah just told you I did, but perhaps a little better. And he is also a trial lawyer and handles lots of litigation matters, including right now we have a number of COVID business interruption cases. He's going to give you a brief review of the current status of things in that regard. And finally, Ron and I will finish this up with some talk about things that are going on at the insurance department in light of COVID. And hopefully we'll have a little bit of time for questions. And in particular, I'm guessing you'll have some questions about Ron's wardrobe choice, as well as for Adam on the employment issues. So thank you for this opportunity. Adam, if you're ready, take it away.
Thanks, Steve, and thanks to everyone for attending, and thanks to PAMIC for inviting us to speak with you this morning. I'm going to, as Steve said, I'm a part of the employment and labor group at Stradley, and I'm going to provide a sort of a survey of what I'd call hot topics in the employment context right now. And obviously, the pandemic is an evolving situation. It's a fluid situation. It's good from time to time to sort of get caught up on where things stand. The law is not always great at keeping up with everything that has been going on over the past year plus, but we do our best. So today I'm going to just run through, and I'm trying to go into slideshow mode here. I'm going to run through a handful of topics that I think are of importance, and catch everyone up on what the latest is on those topics. So just an overview of what I'm going to go through. First, I'm going to talk about workplace safety standards. What does an employer need to do to the physical workspace to make sure that people are safe, as safe as they can be reasonably, given the risk of COVID-19? And that's not been as much of an issue with all the teleworking, the fact that physical workplaces have been closed for the most part in a lot of industries. But now that we're at a kind of a turning point here, it looks like it's going to become an issue. And one of the big upcoming events in that sphere is going to be an OSHA rulemaking that I'm going to discuss in a few moments. I'm also going to go through OSHA issues, reporting issues. OSHA covered employers need to make reports of work-related injuries, hospitalizations, et cetera. And that can raise all kinds of tricky issues, particularly about whether or not something's work-related, given that COVID-19 is kind of in the ether everywhere still, and you never know how someone may have gotten infected. So I'll talk about that a little bit. I'm going to spend some time on workers' compensation issues. Workers' comp is, as everyone knows, sort of the main mechanism for employees to get remedies for work-related injuries. COVID-19 typically is an occupational illness that's covered by workers' comp, although not always. And I'm going to just run through some of the contours of those issues. And then I want to spend time talking about vaccination issues. The vaccine's available now to everyone, and that has generated a lot of good changes. It's made it possible for work places to reopen and for people to come back to work physically after this long, difficult year. But it's also created some challenges because you have to decide whether to mandate the vaccine, whether to encourage the vaccine, and if you mandate, what are the legal pitfalls that you might face. And then on a related note, I'm going to talk about reopening issues that come up in the context of the Americans with Disability Act. Folks with disabilities covered by the ADA have certain rights, and there are things that employers need to do to make sure that they are respecting those rights and not running afoul of the ADA. And then at the end, I'm going to spend a little bit of time talking about discrimination, retaliation issues, which always exist, but in the context of COVID-19, there are some sort of novel issues that you may not have thought about before. So as I said, I'm going to start with the current state of workplace safety standards. This is something that's changed a lot over the years. It's a rapidly evolving situation where different authorities are learning more and science is evolving. And as that happens, more government action takes place that can give employers an idea of what exactly it is they need to do. So I'll start with the sources of authority you can look to. And at the top of that pyramid is presidential executive orders. There was an executive order on January 21st of this year. I think it was the first full day of the Biden administration, which there were a number of executive orders, but the one that is most important to know about is the executive order on protecting worker health and safety. And that executive order contained an instruction to OSHA that OSHA should consider issuing an emergency temporary standard, which is basically an emergency regulation. It's a very rare thing for OSHA to do. But the executive order directed them to consider whether it's appropriate here, given the pandemic, and if so, to issue that ETS. And the executive order said that the OSHA was supposed to do that by March 15th. That deadline's long passed and it didn't happen. However, it did recently, OSHA did recently send over that proposed ETS to the White House. We don't know what's in it yet, and I'll get into that in a few minutes, but that's something to keep an eye on. There also were a bunch of miscellaneous orders that had to do with school reopening and mask wearing, mostly applicable to school employees and employees of airports, other, in transportation industries and things that are within the purview of the federal government. Federal agencies have some ability to create workplace standards. The CDC, everyone knows, has been issuing a series of guidelines during the course of the pandemic. The CDC really doesn't have much authority to take any action or mandate any particular safety standards. What it can do is it can detain people entering the country. It can medically examine those people and can do the same thing with respect to folks who are traveling between states who are suspected of carrying the virus. Other than that, CDC policies are non-mandatory guidance, although they're important because one, they inform what federal, state, and local health authorities might do in terms of mandatory guidance. And two, they end up being evidence that an employer acted reasonably in trying to protect workers. And that's another issue I'm going to get into later on. OSHA is a little bit of a different story. It does create mandatory standards, health and safety requirements that private employers covered by OSHA have to follow. There are states that have their own state plans. And in those states, you have to follow the state plans. And Pennsylvania is not one of those. So it follows the rules created by OSHA. As I mentioned, the OSHA ETS is forthcoming. It was sent on April 26th, it was sent to the White House Office of Management and Budget, Office of Information and Regulatory Affairs, which is the last step before it takes effect. It's under review right now. The expectation is that it will come into effect at some point in June at the latest, probably no sooner than June and likely in June. Once it does take effect, there are probably going to be, almost definitely going to be legal challenges. The last time OSHA established an ETS was in the late 70s. It had to do with asbestos exposure, and it actually was invalidated after challenge several years later. So this is a rare thing. It will be challenged, but in the meantime, it's something that employers are going to have to adhere to. The content of the ETS is not known yet. However, the speculation is that it's going to contain strict requirements, and specifically requirements that might be based on the California state plan, because the former head of California's OSHA recently became the head of OSHA. So there's the inference is that he's going to impose requirements on employers similar to what California did. And that could include a number of things, including preparing a written COVID-19 prevention plan. It could have face covering mandates, could have mandatory reporting of cases, mandatory testing, and it could require employers to pay employees when they have to quarantine or isolate due to some exposure to the virus.
Adam, before you
Yes.
move on, we do have one question. So as we get them, let me just read it to you. And if
Yep.
you can respond, I'd appreciate it. What are the COVID injury reporting requirements if an employee, while not working at the employer's office or workplace, reports positive COVID test and symptoms without certainty about contraction at workplace? An employee believes and reports likely contraction wasn't related to employment itself. So I guess what they're saying is, okay, an employee gets COVID, not necessarily at the workplace, but they do have COVID. Do they have a requirement to report to their employer that they actually have contracted COVID?
It's a good question. The question is whether the employee has an obligation or whether the employer. The employer can only.
The employee.
Yeah, I'm going to get into OSHA reporting in detail in the next section. But
so why don't we wait for that, and
sure.
And everybody can anticipate it. Thank you.
Sure, no problem. And but briefly though, the obligation is really on the employer, not the employee, and the employer can only act on the information it has. So OSHA regulates employer conduct. The presumption is that if an employee, in other words, if the employer doesn't know about something, it can't act. And I think that might be the short answer, but I'll get into greater detail about that in just a few minutes. So the last source of authority for workplace standards I want to talk about is just state and local governments. They have a police power, and they're empowered to protect the health, safety, and welfare of persons within their borders, and that includes isolation and quarantine orders. We've seen those in Pennsylvania and elsewhere. Those are mandatory. Employers have to comply with those, and they can issue those state and local entities, government entities can issue fines, penalties, et cetera, and they can in fact shut down businesses. So the strongest power is at the state and local level. There's been a spate of litigation related to workplace safety standards. There have been all kinds of attempts to get around workers' compensation and make claims directly, sort of tort claims against employers for failing to take adequate safety measures. I'll get into the workers' comp specific issues in a minute, but the key takeaway here is that if you want to make sure you mitigate your risk in connection with those lawsuits, following all these workplace standards that I just discussed is very important. You will generate evidence that you acted reasonably, that you met any duty of care you might have had, and a big part of that, as I'm going to get into now, is OSHA reporting, and the question we just got was about that. Work-related COVID-19 cases do have to be reported, and also workers' compensation issues. If you handle those correctly, you can significantly mitigate your risk, and that often really involves directing claims into the workers' comp process and making sure that they don't become full-blown lawsuits. So OSHA reporting, this was the subject of the question. To get back to the question, I'm not aware of any obligation on the part of an employee to report an injury. But theoretically, I would think an employer would know if an employee had COVID-19 and then would have an obligation based on that knowledge to inquire about whether it's work-related or not. And that's its own analysis that OSHA has issued some guidance on, and that's the subject of a slide that I'm going to put up in just a sec. But generally, the scope of OSHA reporting obligations is it covers employers, and employers in certain industries have to keep OSHA logs of illnesses and injuries. All employers have to report hospitalizations and deaths. And if you don't make these reports, it can result in penalties. OSHA, last I read, OSHA has issued fines as of the end of 2020 in the amount of, I think, $4 million. That's not all about reporting issues, but in part it is. So it's an important issue, and something you want to make sure you do correctly. The protocol for reporting a COVID-19 case as a work-related injury or illness is, obviously, you want to first confirm that there's a positive test, and that in fact the employee has COVID-19, and then next you want to investigate and ask questions of the employee about what exposures that person may have had that were work-related, and what exposures may have been non-work-related that might have caused the person to become COVID-19 positive. And then, of course, you want to keep documentation of those responses and keep a good record. The question obviously is, and I think this also gets at the question we received, what is work-related? Because COVID-19 it's invisible. We don't know where it is. You can't really avoid it other than avoiding exposure to people have it. And there are precautions you can take, but the question is, did someone get it while they're shopping at the supermarket, or did they get it at work? And that's a hard question to answer. So OSHA has issued guidance on this that helps a little bit. And the guidance says that the COVID-19 illness likely is work-related if, and all these are assuming no alternative explanation. Several cases develop in a short period of time among employees who work closely together. That creates an inference of work-relatedness. The illness develops after lengthy close contact with a member of the public at work or coworker with a confirmed case. That too would make it more likely that it was a work-related illness. Or the employee's job duties involve frequent close contact with members of the general public in an area with high infection rates among the public in a locality with ongoing community transmission. There are a lot of parts to that one, but I think these are pretty self-explanatory. These are standards that you can at least attempt to apply in investigating whether a case is work-related or not. And if it meets any of these criteria, you may want to conclude that it is, and to play it safe, just report it. There's also a list of factors that suggest the illness is not work-related or likely not work-related. And that would include if only one person gets it, and the employee, the job duties of that person don't include frequent contact with the public. That would suggest that it was not work-related, or the employee has exposures outside the workplace, and a family member or friend who has or had COVID-19, a non-coworker, and there was an exposure that way. These are not meant to be exhaustive, I don't think, but they're supposed to provide at least a little bit of a framework for doing this investigation. And that's sort of what OSHA has given employers, but it's a fact-dependent analysis, and you need to be reasonable. The touchstone always is reasonableness. If you act reasonably, you should be okay, and you're not going to subject yourself to a fine if you asked all the right questions and took steps that were reasonable in the circumstances. Unless there are other questions, I'm not seeing a stream of questions, although I may not see them. I'll move on to workers' compensation issues, which I'm going to discuss briefly. Workers' comp. Yeah, go ahead.
Adam?
Yes.
Adam, this is Ron. Quick second. I did submit a question, but it didn't get to you yet. So I'll just read it because it relates to the information you just shared. So are there any templates employers can use to document all of the information and questions that you recommend that, or is recommended to ask? And if so, where can we acquire them?
That's a really good question. There are forms out there. I don't think there's an official OSHA sanction form. I don't know the answer to that, frankly. There may be, but it would be easy to find out. I just don't happen to know. The form could be created, though, I think, based on the OSHA guidance, and there's more to it than what I just walked through. The form would just kind of track that guidance. But I don't know whether there's an officially sanctioned form.
Thank you.
That said, I do think it's something that would be easy to put together. So workers' comp, obviously, typical workplace injuries go through the workers' comp system if they're work related, and that's usually fairly straightforward. Someone cuts their finger in a restaurant or something like that happens, and it's obvious that it's a workers' comp issue. COVID-19 is a little more complicated, obviously. And so it raises a host of additional questions that may not be the ones that we typically deal with. So workers' comp is the exclusive remedy for employees seeking damages for a work-related illness or injury. So in most cases, if there's a COVID-19 case, it would be considered an occupational illness and would be subject to a workers' comp claim. That's only not true if the claim is based on some other legal theory under state law, which governs these claims. And there have, as I mentioned before, there have been attempts to circumvent workers' comp. For example, by filing some plaintiffs have tried to file lawsuits alleging a public nuisance, and that's brought on behalf of the general public and not in the plaintiff's capacity as an employee. That might get around workers' comp. There also are issues where an employee sues a property owner for some injury that happened on the property, and then the owner of the property tries to seek indemnity or contribution from the employer, and workers' comp would not bar those claims. So the workplace safety standards I mentioned are important. In the event that someone tries to assert one of these theories that falls outside of workers' comp, although it's not typical and it isn't, a lot of these theories are untested. They are happening. They are being pursued, and so it makes those workplace safety standards all the more important. There's also an exception for independent contractors or visitors, and then finally, there's an exception for willful conduct or intentional conduct that is defined by state law. Typically, you probably wouldn't see a claim where someone said you intentionally subjected them to COVID-19, although it's something that someone could try to assert. But those are the basic exceptions. If you have a positive COVID-19 case, you are required to make a first report of injury. And it involves a similar analysis to the OSHA analysis, which is figuring out whether it's work-related. And that becomes complicated when people are working from home, people are working in different environments. The standard is that if the exposure happened in the course of scope of employment, that triggers an obligation to report it and treat it as a potential workers' comp claim. And that can include working from home. And so you want to, when you're thinking about whether you need to make a report, you'd want to consult with your workers' comp counsel or other advisor to make sure you're obligated to do so. But if you are obligated, then you should do it. And when you defend these claims or when you process these claims, it's best to have them in the workers' comp system, really, because that's where the work-relatedness determination can be made effectively and correctly. And it also, it's a bar to tort claims, so it protects you in that respect. Some states during the pandemic have passed legislation that expands coverage or otherwise adjusts the scope of coverage for workers' compensation for COVID-19 cases. Pennsylvania hasn't done that, but I suppose it still could. I don't know at this late stage whether that'll happen. I think there was an attempt at some legislation that didn't make it through. But in any event, there are a number of cases pending in different jurisdictions that will give employers more guidance on this and help us figure out sort of what exactly is work related and what's not in a context where the workplace often is virtual and there are a whole lot of questions about whether someone got COVID-19 in the course and scope of their employment. So another hot button issue is vaccination. The vaccine is available to everyone 16 and older now. Employers are now looking at what do we do about that? Can we reopen? Can we have everyone come back? And if so, should we require them to get vaccinated? And that's something a lot of our clients are asking about. And they're really, these are three questions. Can an employer lawfully encourage all employees to receive a COVID-19 vaccination? In other words, offer incentives and say, hey, we really want you to do this, and we think it's the safest thing for everybody if you do it. Unequivocally, the answer is yes, there you can encourage it. The question whether you can mandate it is more complicated. And the answer is yes to that as well. But there are a number of limitations and a bunch of landmines you need to navigate your way through if you do it. And a lot of employers, for that reason, are not mandating it, although that's an individual choice and there's no one size fits all solution to it. And then there's a question, should you? And that's sort of what I was getting at just now. Should you mandate that everyone get vaccinated? And obviously the answer is to that is maybe you should, maybe you shouldn't. And there are a number of factors that bear on that. The legal limitations on vaccination mandates are, first, as I said, you can encourage people to get vaccinated. And some employers have done that by saying, if you want to go get vaccinated, we'll pay you for the time. And there are any number of other incentives you could offer. And that's totally fine. And there's no limit on that. It's lawful for an employer to mandate vaccination. However, there are laws and obligations that the employer has to meet if it does that. And the big one is if someone has a disability protected by the ADA and medical condition that substantially affects their ability to do the job, and they claim that they can't get vaccinated because of that, the employer has an obligation to provide a reasonable accommodation if one's available without undue hardship. And I'll get into that in a little more detail in a minute. But that's sort of the big ticket issue. Another less prevalent issue is accommodating religious issues. People with sincerely held religious beliefs and that they say prevent them from getting vaccinated are protected by Title VII. And employers have to be mindful of that as they interact with employees about whether or not the employee can get vaccinated or will do so. And then there might be other limitations under state and local law. That's obviously state dependent and locality dependent. And then finally, if you're in a union setting, there could be collective bargaining issues around vaccination. The government has limited authority to mandate vaccination. The federal government can do it for military, and it can do it for immigrants coming into the country, and that's it. states have more authority. They can mandate vaccination for categories of employees like healthcare workers. That's the typical one. Teachers, under the police power, to protect the health, safety, and welfare of persons in the state. The wrinkle with this vaccine, and the reason why it's a little tricky, is that mandates like this usually follow full FDA approval. And this vaccine does not yet have that approval. And it's a novel situation because what it's got instead is an emergency use authorization. And a lot of employees have reservations about taking it for that reason, among other reasons. But that's a frequently cited reason why someone might be reticent to get vaccinated. And that creates unique issues. The thinking is that, if a state, the government mandates sort of operate this way. If a state requires that certain categories of employees get mandated, then obviously the employers who employ those kinds of workers have to, follow the mandate. There have been some states who have mandated that public colleges, universities require their faculty and staff to get vaccinated, and the students. And then other states have said, no, you can't, colleges can't require that. So there's sort of two camps there. And that's something to keep an eye on. But the feeling is that as these government mandates come into effect, it'll become normalized to require vaccination. And maybe society will kind of decide that we should all get vaccinated. And that's fluid right now. But the idea is that as this progresses, the situation, more private employers might end up mandating vaccination over time. There's been some litigation, a couple of cases that I'm going to mention very quickly on governmental vaccination mandates. And this is probably going to continue, and it's going to create precedent for the application of the law to private mandates. In the District of New Mexico, there's a case involving a corrections officer, it's the Legaretta case, who was subject to a vaccine mandate, and he sued his employer for mandating it, arguing that there are a bunch of complicated legal arguments, preemption and other theories, but basically he's saying that because the vaccine is subject to the EUA and is not fully approved by the FDA, federal law basically prohibits mandatory administration of the vaccine. That's an open question whether that's the case. But cases like this one are going to provide guidance to employers on that. And in that case, there was a request for a temporary restraining order, which was denied. But that doesn't mean that the plaintiff won't ultimately be successful. And that case is moving forward. And that again could preview what happens in the law in the future, and it could help employers understand what their risk is for mandating vaccination. There's another case, similar kind of case in California, that involves teachers in the LA school district. It's a group of teachers who've challenged the district's vaccination mandate, making an argument similar to the New Mexico case, the plaintiff in the New Mexico case, which is that it's an emergency use authorization only, and it's not a full FDA approval, and therefore it can't be mandated. That case is still in its infancy, but it will sort of build on it'll create some sort of form of precedent, at least, for whether vaccinations are mandates are lawful. So vaccination mandates also create workers' comp issues. There are decisions about flu shots where employers mandated flu shots, and then the employees had side effects and said that's a work-related injury, and that argument's been accepted. And there will be cases making the same argument with respect to mandatory COVID-19 vaccination. That's very state law dependent, and it's fact dependent. And so we don't really know where that's going to go just yet, but it's something to keep an eye on, because if you're going to mandate vaccination, you may have a you might have a sort of an explosion of workers' comp claims when people say, well, I got side effects. These vaccines are known to have side effects. They're largely temporary, harmless ones, but there are a lot of unknowns. And because it's only an emergency use authorization, people might feel more like, emboldened to make these kinds of arguments. So the bottom line is encouraging vaccination avoids these issues. So it's really a question of what you think is right for your business and what your appetite for risk might be. I want to talk a little bit about ADA issues around returning to work. Obviously, workplaces are reopening. It's going to happen this summer and fall. And there are, and I alluded to this earlier, there are a number of ADA issues that come up in that context. Medical confidentiality. If you're going to do a medical examination as an employer, you need to keep that information confidential. And the EEOC has issued sort of strange guidance saying that administering a vaccine is not a medical examination. So you can do that at work. But if you ask pre-screening questions, which you have to ask before vaccination, that is a medical examination. So it's a little bit of a catch-22. And you need to, if you're going to ask those questions, which I think you have to do, they have to be job related and consistent with business necessity. So it imposes sort of an additional factual burden on the employer. And then you also have to keep the answers to those questions confidential under the ADA. The only way to avoid these limits is to either make the vaccination voluntary and just encourage it, as I mentioned before, or to get employees vaccinated by some third party that you have no contract with, which is, I would imagine, sort of difficult to do, but those are ways to take yourself outside the coverage of the ADA. Other medical confidentiality issues under the ADA, the EEOC said you can require an employee to provide proof of a COVID-19 test and the results of the test. And you can also require proof of vaccination, but you can't ask why an employee who didn't get vaccinated didn't do so. That's considered, an improper question. And then whatever information you get in response to those questions, you have to keep it confidential. And state law might also impose other confidentiality or privacy requirements. If someone has a disability or claims to have a disability and says they can't get vaccinated because of it, then there's an obligation to engage in the interactive process and, if possible, identify a reasonable accommodation. And the EEOC has said that has to include an evaluation of whether the unvaccinated employee poses a direct threat. And what is a direct threat? It's a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. And therefore, factors here that the EEOC has identified that you have to consider in connection with that analysis. And if there is a direct threat and you can't reduce it to an acceptable level, then and only then can you tell the employee that he or she can't come back to work physically. It doesn't mean you can terminate the employee, but it does justify, not automatically, but it does justify excluding the employee from the workplace. If someone says they have a heightened COVID-19 risk because of a disability, that may be a direct threat to the health of that person and require a reasonable accommodation. Vaccination status is going to be relevant to that question, but there's no guidance yet from the EEOC that's specific to vaccination issues. So that's something to keep an eye out for. If the employer is not able to provide a reasonable accommodation, then there's an obligation to look at other options like telework, leave, or reassignment. Telework, which everyone has been doing for the past year plus, we basically proved that it can be done in most cases. And so employees who have been doing it are going to say that is obviously a reasonable accommodation. You should let me do it if I have a disability that's covered by the ADA. That said, employers can require you to come in person, consistent with accepted workplace standards and other restrictions. But it's a delicate thing because you need to have a clear policy. You need to engage in the interactive process for someone who claims a disability. and meet all your obligations under the ADA. And then finally, I'm just going to touch briefly on discrimination retaliation issues. These issues exist independent of the pandemic and always did. But now that we have these novel issues of coming back to work when we haven't been there, figuring out who works when, things like staggering shifts, et cetera, staffing levels, those have to be made based on neutral business factors, and they can't end up discriminating or look like they discriminated against people with disabilities or other protections. Obviously, I don't think people are going to intentionally do that, but it could end up creating problems if it looks like you did. And then training, education training. This is something that, again, you should be doing anyway, but this now, the training should include issues related to COVID-19 specifically, and reminding employees of how they can make complaints. The harassment creates a few novel issues because there's been a sort of an explosion of discrimination claims based on Asian national origin, anti-Asian sentiment around the pandemic, and the EEOC has reported on that. There might also be harassment issues where someone has been taking family leave, paid leave, and hasn't been at work, and other coworkers have some problem with that, and they might harass those folks. And then finally, employees who don't get vaccinated, they might also be subject to harassment if they're not able to get vaccinated or not willing. There could be harassment issues there, and employees need to keep an eye on that. I'm sorry, employers need to keep an eye on that. And then finally, I'll end with this. Retaliation obviously is something that's always there. You can't take an adverse employment action against someone who engages in a protected activity, and that includes invoking legal rights around COVID-19, such as getting an ADA reasonable accommodation, taking paid family or medical leave, and other activities. And employee reports and complaints also can create retaliation issues. OSHA-related reports and whistleblower complaints, and then other complaints that an employee might make about workplace health and safety. So that was a quick rundown of the hot button issues that exist right now. I hope I didn't go over time. I think I may have, but I'm going to turn it over to
Adam, thanks so much, man. That was really, really great. And there actually is a question for you, but to keep us on schedule, and I know everyone wants to go to lunch on time for sure. Maybe you could answer that question by typing it.
Sure.
I actually don't think we're going to have a lot of time for Q&A at the end of this, but that was fantastic. And I don't know if we're going to switch screens so everybody can watch Jeff talk about COVID litigation. Thank you so much. Thanks.
Steve.
You all set, Jeff?
I am. Am I visible?
You are.
Okay. Hi, everyone. It's great to be here. And in respect of time, I think I can be a little bit quicker than I had planned to just keep things moving along. We're all familiar with the 1,700 approximate COVID-19 business interruption lawsuits that have been filed since the beginning of the pandemic. There's been lots of decisions by federal and state courts ruling on those cases at early motion to dismiss phases, and by and large, the insurers are faring better than the policyholders, particularly within federal court. What's new and interesting in this area of law is that the play has moved to a new stage, and that stage is the appellate courts across the country. Right now, or at least as of Monday of this week, by my tally, there are approximately 120 cases on appeal. 3 of those appeals are before the highest courts of 2 states in the District of Columbia. So in Ohio and in DC and in Oklahoma, the highest courts in those states are going to decide the legal issues that are central to these cases. And primarily those legal issues are twofold. Number one, is COVID-19, does it have an ability to create a direct physical loss or damage to insured property? And the second issue is the enforceability of the virus exclusion, whether it's ambiguous, whether it's enforceable, whether there's any regulatory estoppel that could preclude its enforcement, So basically the coverage grant of direct physical loss or damage and the virus exclusion are the two primary issues in these cases. So we've got 3 on appeal at the highest court levels in 3 different jurisdictions. That's going to be very interesting and pivotal, those cases. And we also have appeals in 23 other states. So more than half the states across the country and the District of Columbia, I'm sorry, just about half the states in the District of Columbia already have cases on appeal. And there are also cases in the federal system with the 3rd Circuit, the 8th Circuit, and the 9th Circuit Courts of Appeal. Now let me focus on what's happening in Pennsylvania, which is near and dear to all of us. In our 3rd Circuit Court of Appeals in the federal system, there are at least 14 cases that the 3rd Circuit has consolidated for briefing and argument purposes. These are all cases where either the Eastern District, Middle District, or Western District of Pennsylvania have dismissed the policyholder's claims for business interruption coverage. And those cases variously hold that there's either no direct physical loss or damage as a result of COVID-19, or they hold in addition to or separate and apart that the virus exclusion precludes the plaintiff's policyholders from proceeding in those cases. Those cases, as I said, are consolidated. The records below in those cases have to move from the trial courts to the appellate court. That process is taking some time. And once all of the records are with the 3rd Circuit, they will enter a briefing schedule. So there's no briefing schedule yet in those cases, and they will be consolidated and decided by one panel of judges, 3 judges who sit on the Circuit Court of Appeals. That panel has not yet been assigned. There are also 2 cases pending now in the Superior Court of Pennsylvania, which is our intermediate Court of Appeals. We have the Court of Common Pleas, which is known as the trial court level. Then appeals from the Court of Common Pleas either go to the Superior Court or the Commonwealth Court. These 2 cases are in the Superior Court's jurisdiction rather than the Commonwealth Courts, so that's where they sit. And then appeals from the Superior Court go to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court does not have any case pending before it, and I say yet because there is a path through the federal court system where one of those 14 appeals, or all of them on a consolidated basis, could go right to the Supreme Court on what's called a certification of a question. The 3rd Circuit can be asked, or in its discretion can decide that there is a novel question of Pennsylvania law that's been put before them. And rather than predict how a Pennsylvania court or the Pennsylvania Supreme Court would decide that issue, they can ask the Supreme Court to decide it. And we may see that happen so that the cases in the federal system can sort of leapfrog the cases in our state system and go right to the Supreme Court on the pivotal issues of direct physical loss or damage and or on the virus exclusion. Now back to the intermediate court, these 2 cases that are now pending. The first that was filed was out of Lackawanna County. The name of that case is the Scranton Club, and the defendant insurer in that case is Tuscarora Wayne Insurance Company. The trial court, Judge Nealon presiding, decided that COVID-19, as alleged in that case, did not present any direct physical loss or damage to the insured's property, and the claims were dismissed. Judge Nealon, who rendered that decision, would not dismiss the cases on the basis of the virus exclusion, but because there was no coverage, the case ended there, and the Scranton Club appealed to the Superior Court of Pennsylvania. That is the lead case in Pennsylvania in terms of a timeline, because there's now a briefing schedule entered in that case. None of the other cases in Pennsylvania, federal or state, have a briefing schedule yet. And the Scranton Club's brief is due on June 1st. And under the rules, if no extensions are granted, the insurer's brief would be due within 30 days of being served with the Scranton Club's brief. And then once that happens, there's a 14-day period for the Scranton Club to file a reply brief. So if everyone takes as much time as possible, which is usually what lawyers do, then the briefing should be done by the middle of July. That would take, yes, to the middle of July. And then the panel will assign an argument date. An argument will be had. There may be some amicus briefs filed by some of the trade groups, both on the insurer side and the policyholder side, and then the case will be decided. And of course, the loser in that case does have the option to appeal to the Pennsylvania Supreme Court. The other case that's pending in the Superior Court level is out of Allegheny County, and it goes the other way. In this case, Ungarine, which is a dentist business, Ungarine DMD versus CNA, Judge Ward decided that the loss of use of the business, because the dental business could not be used to its full capacity during the period of the shutdown orders, that constituted a direct physical loss or damage to insured property. She did not require the policyholder to show physical loss or damage. She was satisfied that loss of use was enough to trigger coverage. So the insurer has appealed in that case. And that case, in terms of appellate work, is at a very early phase. They're still filing papers with the trial court to try and get clarification on what sort of judgment was entered, whether it was a final judgment that was appealable or whether it was what's called an interlocutory order, which is only appealable in limited circumstances. So where that case goes from here still remains to be seen, but a notice of appeal has been filed. And that is the status of where these cases sit locally in our appellate courts.
Hey, Jeff, I just wanted to add on the amicus front, and in part because I know Ron's been involved in this, it does look like the trades, including PAMIC and the Federation, as well as the national trades, NAMIC and the AICPA, are going to help and file amicus briefs in the Tuscarora case. They've filed amicus briefs in other cases, and so they're pretty much in the can, but we've been advised that that's being put together, and I know Ron's been actively involved to make sure PAMIC participates in that as a amicus. So I think that's a good sign.
Right, correct. Thanks, Steve.
I'm sorry, Jeff, were you done or did I cut you off?
Over and out, sir.
Is Ron with us, or is he?
You know, Ron is on the call. Can you hear me, Steve?
We can.
Okay, I'm having some video problems.
That
Not
was
so
my
much because
wardrobe
of my
joke.
looks, but because of, I guess, some capacity issues here at work. So we're going to take the next, according to my clock, 7 or 8 minutes to talk a little bit about things that are going on in the department. And Steve and I, who have known each other very well for many, many years, and I want to give a little bit more background. Steve was the chief counsel at the insurance department when I was one of the deputies there, and we formed both a very professional and private friendship, and we've maintained that over the years. And the PAMIC board actually appointed Steve as our board counsel as well. So Steve is intimately involved in a lot of these kinds of things that PAMIC is doing. And it's great to have somebody I know, I trust, and is an expert. With that, Steve, I want to turn it over to you and just talk a little bit about what you kind of understand is happening in the department, and then we can go.
Do we lose Ron completely? I think I knew where he was headed, so I'll just real quick. We've been, of course, in touch with the department, and many of you on this call probably participated last year in some of the departments. I forget what they were called, but they gave, bi-weekly meetings sort of talking about what's going on and how to deal with what's going on with COVID. So I talked to a couple high-level people who did not give me permission to say who they were, but what's going on is they are planning to return to work in July. Much of the current telework, the plan is that will continue though. So it'll be return to work on a very limited basis. And there's a lot of DGS issues they have to deal with on that. But right now, the plan is that a lot of the folks that have been working
Over
remotely.
some of the other things.
Hey, Ron, are you with us or? Sorry, I think we're echoing now. A lot of the folks that have been working remotely will continue to do so. And with that, I think the department's very keen on some of the streamlined procedures that they put in place last year concerning electronic versus paper, maybe some of the signature issues, electronic signatures and things like that. Right now, the hope is that they're going to continue a lot of that stuff and actually are amenable to considering even more streamlined procedures if it makes sense, since a lot of their employees are going to continue to work from home. So that's
Steve, hold on a second. And with that, I ask you, our membership, to email me with any types of reporting requirements that mandate hard copy.
Did Ron cut out again, or is it me? Jeff, nod your head. I apologize if I can't hear Ron right now, so I'm just going to keep yapping for a minute or two.
Yeah, Ron is cutting out, unfortunately.
Okay. Another thing coming up that the department hasn't publicly announced yet, but I understand they're going to provide Ron and as well as the Federation a sneak preview. In July, they are going to, or I'm sorry, in June, they are going to have a new portal system for, I guess what they're calling new products, innovative products, or new market entrants. And it's not exclusive to new entrants. It can be current members.
Copy recording or something along those lines. These done electronically. It's me.
Hey, Ron, I don't know what your malfunction is, but I can just run us to lunch if you can't get back on. Just real quick, it's modeled on New York's Next Fast Forward portal, and that actually is going to come online in June. They're very excited about it, and it's really geared toward having communications with carriers who are having novel products that they want to introduce, and I was assured that Ron would get a sneak preview, so hopefully he'll be sharing that with members. There have been some personnel changes. We're getting a new administrative hearings office judge. That selection has been narrowed down. I think an offer may have been made, but the individual's name has not been made public, but we should be getting a new administrative hearings office judge in the next, could be any day. We have a new policy director whose name escapes me, but I don't know whether anyone on the phone has to deal with that. I can see some names that I know do. And Kashik Patel on the financial side retired, and I think his last day is, I'm not sure when it is, but he's essentially out of pocket. So that's news for folks who have to deal on the company side. And finally, and Ron was going to talk about the COVID notice and another notice that the department issued just privately. And Ron's been involved in dealing with the other notice in particular. The COVID notice really has to do with providing information in connection with rate filings pertaining to COVID-related data that may impact your pricing. In essence, the notice put everyone on notice that that was really what had been going on inside the department for months anyway. McKinney's group was requiring that information for filings, and rather than issuing you an objection notice, now you're all on notice that you need to provide that information on the front end. The other notice is a lot more complicated and has to do with rate requests on coverages where we don't have data necessary to put pricing in effect. They received some I was told that it was received as very constructive feedback from PAMIX members. So, kudos to Ron again for getting out in front on that. They have not met again since they received the feedback, but I understand that they are taking the feedback to heart and are going to try to do what they can to tailor that notice in a way that is more beneficial than the draft they circulated, which I know a lot of you saw. And I see Sarah popped on, so she's giving me the signal because it's lunchtime, so I'm going to shut up.
Well, lunchtime is definitely important, but what you had to tell us was pretty important too. Thank you so much to the three of you and Ron back there in the ether somewhere for this very interesting session. Okay, we're going to take 45 minutes and be back at 1 o'clock when we're going to have a little peek behind the curtain at injury claims from the plaintiff attorney point of view, followed by our final session, which will involve dog liability issues. So have a great lunch, everyone. See you at 1.
Thanks, everybody.
You're welcome. Bye-bye.